The property market in most states at the moment is hot. And in such a market, it's quite common for parties to enter into pre-contract arrangements before formal contracts. Recently, I've come across heads of agreement purporting to be binding on the parties, as well as signed letters of offer, and contracts being exchanged by way of email or fax. So the question to ask is whether these arrangements are legally binding and enforceable. There has been some guidance on this from the courts, and I thought it would be useful over the next few minutes just to give some guidance to vendors and purchasers whether or not these arrangements are binding and enforceable. You should bear in mind that whether or not these arrangements are binding will depend on individual facts of your case. The first thing to bear in mind is that it is unlikely that heads of agreement and letters of offer are going to be binding arrangements. It's quite a widely accepted principle that if documents contain the words subject to contract or subject to formal contract, then these arrangements will not be legally binding. There was a case where a vendor went to market and advised a number of purchasers that they would accept the highest offer by a certain time and date. After the time and date had passed, the vendor refused to exchange contracts with the highest bidder. In that case, the court actually held that that vendor was not legally obliged to exchange contracts with the highest bidder. However, I note that the vendor's tender documentation in that case did contain the word subject to contract. The other thing to note is that even if your document purports to be legally binding on the parties, that does not necessarily make them legally binding on the parties. For those documents to be legally binding, all the essential terms, including price, the amount of the deposit, the names of the parties, settlement date, etc., needs to be agreed to by the parties. It's quite likely that a court will hold that a deposit will also be required to be paid by a purchaser for that arrangement to be legally binding. If parties are entering into negotiations pre-contract, they should consider entering into a deed of exclusive dealing or a confidentiality deed, as such arrangements will give rise to legally enforceable arrangements and possibly damages lawsuit if there is a breach of these arrangements. There's no reason why such arrangements cannot contain any liquidated damages clause as well. The next thing to bear in mind, especially for purchasers, is that there is no binding contract until a vendor has provided the vendor's signed counterpart to a purchaser. So it's quite possible for a vendor to have several counterparts signed by different purchasers without any obligation to exchange any of the contracts. And the vendor may in fact have a right to withdraw the property from the market. If you're a purchaser, it may be worth, when submitting your counterpart to the vendor, considering either having a expiry date and a time on the offer, or reserving the right to withdraw the contract from the vendor, and this may prevent a vendor from using a purchaser's offer as leverage against several competing offers. It is possible to exchange a contract by way of telephone and fax, especially if the entire contract is faxed to the other side shortly after or at the same time as the telephone conversation. And bear in mind that the entire contract, and not just the execution clauses, has to be faxed. This does extend to email exchange, especially if other parts of the agreement does contemplate email communications. However, it's worth pointing out that you should try to include somewhere in the contract a right to exchange documents or give notices by way of email in order to make this happen. It's quite common when you exchange contracts by way of fax or email that certain parts of the contract go missing, or there is clauses missing, or otherwise the two counterparts are not identical. And in this situation, a court has held that a contract may still be legally binding as long as the material terms and pages are contained in the contract, and what's missing is essentially non-material or just mechanical parts of the contract. On the other hand, if any material terms are missing, such as subject to finance clauses, then courts have held that there is no exchange of contracts and those arrangements are not legally binding. As I said, it will depend on your individual circumstances whether they are legally binding or not. However, please feel free to email me if you have any queries. Thank you.